Andiero with Blue to Gold Law Enforcement Training. I want to make a quick video on a question that was asked of me by two different officers in two different states very recently, and it's a great question, and so now I want to share the answer with you folks. So the question is can police run a drug canine around a car in a parking lot? The answer is yes, because under those facts, the police did not conduct a Fourth Amendment search. And now here's why. Running a canine, first of all, a drug canine, that canine picks up the scent of narcotics. Narcotics are illegal to possess. Therefore, a suspect does not have a reasonable expectation of privacy in that scent that's emanating from their car. That's going to be, during the free air sniff. So that's the first part. The second part is that the dog is lawfully present. When cars are in parking lots, whether it's Wendy's, Motel 6s, Love's truck stops, and so forth, the suspect can be there, but so can police. Nothing prevents a police officer from looking into a car. Now, I wouldn't want to touch the car and manipulate anything, but right to be, right to see. And so because the officer can be outside of the car, so can his best friend, the canine. The canine can also be outside the car, and that is the epitome of a free air sniff, requiring no legal justification. And so that is what's going on. Now, you do want to make sure that the dog is lawfully present. So, for example, we have a case called Jardines, where police brought Frankie, the drug-sniffing dog, onto the curtilage of a suspect who was allegedly growing marijuana. Now, he was growing marijuana, but at the time it was allegedly because they got an anonymous tip. The police brought the dog onto the property while doing a knock and talk, and the dog alerted. The U.S. Supreme Court found in that case that was a search under the Fourth Amendment because the police had no implied consent, essentially, to bring that dog onto curtilage during a knock and talk. That was something that most people would not implicitly allow police to do, and it makes sense. And so because the police were trespassing while they brought the dog, they're trespassing because they brought the dog, therefore it was a search under the Fourth Amendment. But take that same scenario in the parking lot of Wendy's, right? Or the motel is, where cops are probably going to deploy the dog more often. Police can be there, just like the suspect can, again. And also, you do not need the manager's permission to be on the property. Whether or not police get it, that's a totally different issue. But the suspect has no right to exclude police officers from that parking lot. So it's irrelevant whether or not police got consent from the manager, right? That person, even if the manager did not consent, right? And the suspect brings that up in court. The problem with that is that the suspect has no legitimate privacy interest in that parking lot because there's no right to exclude anybody else. They are just a guest. Now, the manager can certainly exclude people. The property owner can certainly tell police that they're not allowed to be there, but that's a completely different issue. If we want to use evidence against that person, the manager, landowner, then we may have an issue, but not as to the suspect. And I hope that makes sense. So, just to summarize, running a dog around a vehicle is not a Fourth Amendment search. The sniffing itself is not a Fourth Amendment search. And as long as police have a right to be in that parking lot that's open to the public, just like the suspect does, that does not implicate any Fourth Amendment concern, period. Cops can do it. They don't need any justification. I hope this helps. I hope you found it interesting. If you have more questions like this, please email me at anthony@bluetogold.com. Until next time, stay safe.